UK today, a court hearing is being broadcast for the first time in that country's history. So a person who's been convicted of a crime will receive their sentence while the event is being filmed and broadcast. This has been common practice in our courtrooms. Under our current practice, journalists will apply to a judge or magistrate for permission. Generally speaking, that permission is granted, which is why we all had to suffer through the Oscar Pistorius trial. But it's also how we were able to bring you really important arguments and rulings in the Constitutional Court or other criminal cases on a daily basis. William Bird is the Director of Media Monitoring Africa. He joins us now. William, good afternoon. Is filming and broadcasting a court case always a good idea?
Well, good afternoon. Not always, but I think frequently it is a good idea. You know, from the early days of our Constitutional Court, they were really interested in trying to get people to see that in a new dispensation under a democratic regime, justice is not something that should be administered from on high down to people. It's something that people should think about, should engage with, should learn and understand about, so that they can see that justice is being done and how it's being done, you know. And so that's been a really critical lesson from our Constitutional Court. It really is one of the most wonderful things that they've given us, the sense of commitment to open justice. But of course, not every case is going to be good for everyone to watch. Often, for example, in a commercial crimes matter, you may just be going through reams after reams after reams of paper and paper and paper, and it may be thoroughly boring to watch. You mentioned in your intro the Oscar Pistorius trial. That's, of course, a great trial, because suddenly it's about murder, it's about a tragedy, it's about things that people can identify with. And to get the viewing public, to get ordinary members of the public to see how our criminal justice system actually can work is, I think, ultimately an empowering thing to be doing. So generally speaking, it's a good idea, with caveats, obviously.
I'm going to come to some of those caveats in a moment. I mean, I think to sort of build on your point, something that struck me, certainly in the conversations I've had with people, is you look at the findings of the Zondo Commission, and people understand the findings so well because they were able to watch the testimony, listen to the testimony themselves. No one could say the findings were a surprise, and you could decide for yourself whether you accept or reject the findings based on what people saw. So if, for example, Mosebenzi Zwane decides for some reason to reject the findings, he and I can have an argument based on what we both saw.
Yeah, exactly, and that's such a critical point, because it means that anyone can go and watch that. It's still available on YouTube. I think all of those hearings, or certainly on the sites, you can actually go back and watch them again if you're that way inclined, you know. So that it really does open up not just the justice system and how it works, but as you point out, it means that I can sit there and decide, yeah, I don't like this person, or I think that they're not credible, or why don't you ask this question, or what happens here, you know. So it gives you a real path and a means of actually opening justice up. And then, of course, what you want is that your media then have experts who can then unpack that. They can explain terms, they can explain why the court did certain things that may not make sense to ordinary people like you and I who aren't involved in that. But media experts, they can go there, they can say, well, this is what's going on. So it really does mean that it's a key part of our democratic functioning is opened up to the public, and that's always a good thing, you know.
I've often wondered if it does make life harder for some people. Maybe the people who are accused of a crime, we can have a sort of bigger conversation around that. But sometimes a person is a witness in a case. So they just happen to be walking down a street, and they're in a certain place at a certain time, and they're subpoenaed. They have to come and testify. And some people, unlike myself, are naturally shy. They now suddenly will find themselves on TV. They may wear clothes that people consider uncool. They may speak in an interesting way, or an old-fashioned way, perhaps. And suddenly they find themselves being mocked on Twitter in the discussion, and the subject of discussion against their own will. That, for them, might actually lead to a very traumatic process. I mean, you just happen to be in a shopping center during a robbery, and now suddenly you're trending on Twitter, and you're a private person. Do we need to maybe have some kind of protection for people in that position, you know, particularly witnesses?
So you'll remember that there are those protections already, in fact, and our court is very open because it's still a relatively new thing. And in fact, again, our court, this isn't just something that's new for our court, but we now have a default open assumption. That's, again, our Supreme Court of Appeal was the first in the world to set that precedent, to say that media should be allowed unless you can make an argument as to why they shouldn't, right? So if you are a person that can put forward legitimate and compelling reasons as to why the media shouldn't name or identify you, then your lawyer or your legal representative can make that argument to the court, which is a good thing. When it comes to children, obviously, there's already a whole range of other protections that immediately kick in anyway, so children won't be identified. We saw our courts being really creative with this in the Eugene Blanche murder case, where, for example, one of the accused was, in fact, was a child at the time of the committing of that crime, and so no one ever saw that person, even when he was in court. The cameras weren't allowed to show him, so his identity was very clearly protected. So there are ways that you can get around it. But I think, it's easy to then blame the media for the kind of scenario that you set out. What we forget is that the justice system, for all that it's good that we're opening it up, there are a lot of things about it that I think are entirely brutal. We would have seen the cross-examination of a lot of witnesses would put many people off going and being a witness just to begin with, because you think, my goodness, my character is going to be assassinated just to defend some person who may be guilty of sin. And so there are a lot of things about the actual criminal justice system that are really, really unpleasant to begin with, let alone dealing with that additional trauma of the social media backlash that many of you people are going to experience. So it's not to say it's an easy thing to always achieve, but I think it's, in general terms, we need to find ways of managing those kinds of scenarios and less about saying, well, we shouldn't then show anyone as the default response to that.
It's quite hard to think of an argument against opening the court, especially as a journalist. I'm someone who always wants as much information as possible. But one argument could be, maybe this happened with the stories, it certainly happened with the O.J. Simpson trial, which was largely open, is that there's a sense of sensationalism. In the United States, there's actually a thing called court TV. There are other people, other broadcasters, who've made an entire career out of focusing on particular court processes, and the way they do it is that they will take a 15-second interchange in court and make that the basis of 2 hours of discussion. Now, it's great television. I mean, it's addictive television. It's not great for human beings, though.
No, it's just very much like the Johnny Depp Amber Heard trial. I think that really was a low point in sort of unpacking and getting into the nitty-gritty of just how brutal, relationships, personal relationships, intimate relationships are. The kind of level of detail that you get exposed to, that sort of level of trauma, I really think is certainly not going to be helpful to a society to actually understand how defamation cases work, for example. That was very much about the celebrity, and in fact there was a strong argument about the January 6 attacks on the Capitol in the States, that they actually engineered that process so that it was more television friendly, so less about the actual judicial process and more about the fact that they wanted people to watch it, so they had to find ways of making the testimony more interesting to watch. So they encouraged video and all those sorts of things. So it does bring into question that entertainment versus public interest against what's of interest to the public, and that whole kind of argument, and there is an argument to be made that some people will play to the camera. Of course, in South Africa, it's less of an issue because we don't have a jury trial, so it's not as though that person is playing to someone who potentially as a jury member could then make an alternative decision, but they are then actually speaking to a judge, and judges by and large, they don't engage in these things. Many of them aren't even on social media. So you do have a number of things that I think as part of our new foray into greater open justice, we're going to need to find balance. Some of those are that issue about making sure that you don't play it up to the public, and the courts are going to have to probably find some good rules and mechanisms to enforce there. If they think a lawyer's, wafting and speaking to the camera too much instead of to the issues, they'll need to rein them in. But I think in general we're going to find our way through that as we go, and that'll happen, with good practice and good precedent, we hope.
William Bird, thanks very much indeed. Do appreciate it. William Bird, of course, is the Director of Media Monitoring Africa.